H&D Hobby Distributing Ltd. Is the plaintiff suing the defendant Alex Vatos for $24,009.26. This is the amount owed for hobby goods and supplies H&D Hobby supplied to Alex Vatos. The goods supplied were shipped and billed to Edmonton Hobbies, a trade name for the numbered corporation 327401 Alberta Ltd. Two key issues are present in this case. Firstly, Vatos claimed limited liability due to operating as a corporation. However, Madsen testifies that he was not aware that he was dealing with a corporation at all. Did Vatos incur personal liability for not following provisions found in the Business Corporation Act, which essentially states that a business must clearly set out its name in all official documents? Secondly, usually a company's shareholders and directors have limited liability from lawsuits. However, in this case, Alex Vatos is the only shareholder and director. Is Vatos personally liable as she is the controlling mind behind fraudulent and dishonest acts as a corporation?
Order in the court. Plaintiff, defendant, please explain yourselves.
I used to work at Northern Hobby. Hans Madsen was an occasional supplier, so we were well acquainted. Northern Hobby closed a while back, and I had an idea of starting my own business. And that's when I approached Madsen about supplying products for my own business.
Given our professional relationship, I admit that I agreed to give her the product. But I had no problem doing that.
But in this case, Alex has testified limited liability as a corporation to avoid being personally liable for paying restitutions.
Well, Your Honor, I had no idea Alex was operating as a corporation.
But I explicitly told Madsen that I'll be using a numbered company. That's when he sneered at me and told me to get a real name for my business.
I see. Alex has offered proof of the existence of the numbered corporation. Being under oath, I also accept that Madsen had no recollection of said company. However, Alex has provided checks as evidence to the court using the name Edmonton Hobby, which is the trade name for the numbered corporation. As a subtitle, it also included the numbered corporation name. This is the only proof of the company.
But, Your Honor, I have no recollection of ever seeing these checks, although I do have a subledger handling Edmonton Hobby.
Other than the produced numbered checks and the alleged lease of the business premises, there is no other evidence stating the official corporate name. Alex, please continue the explanation.
I approached Madsen about opening another store. I have a copy of a letter signed by the both of us for the planned quadruple investments in my business. We were in financial difficulties, however I hope to turn it around through opening a store during a profitable season.
But there's no corporation on the letterhead. It was just a personal letter with no mention of the company. There was just the trade name Edmonton Hobby. I again assumed it was just a personal business, considering she already owed me about $6,000.
Madsen, why did you agree to go about further investing in Vatos when she already owed you $5,717.42?
Well, I trusted her. I had faith in her integrity, and she sold me on her plan. So I invited her to come down to Calgary to talk it out, put it in writing. She came down, I agreed. I trust her personally to pay me back.
I find that Madsen didn't know he was handling a corporation and viewed this as a personal matter. I came to this conclusion because Vatos has failed to produce a lease using the numbered corporation. Madsen claims no recollection of seeing the checks and argues that he thought that the trade name was just for a sole proprietorship. And further, I find that Vatos was aware that she was operating as a company. It was Vatos' sole responsibility as a shareholder, director, and operator of the corporation to tell Madsen that she was operating as such. To have avoided personal liability, she would have had to comply with Section 10(8) of the Business Corporations Act.
This act states that a corporation shall set out its name in legible characters in or all contracts, invoices, negotiable instruments, and orders of goods or services issued or made by or on behalf of the corporation.
He has failed to do so, and the posting of the checks with the corporate name were not enough to make a case. Furthermore, the quadrupling of investment seemed to be more of a personal undertaking than a corporate endeavor. Vatos, why do you now owe $24,009.26 and are unable to pay it back?
In 1997, the business was failing, So I sold all of my assets to Capital City Savings. I had to do it to make rent and to get the credit union off my back.
Even though the assets were in your warehouse, our contract and its conditions state that I held ownership until they were sold.
It appears that Svatos has violated the contract's conditions and has acted unjustly. Furthermore, she has improperly given preference to creditors.
Unfair preference is a legal term arising when a person or company transfers assets or pays a debt to a creditor that leaves one creditor in a better position than the other, unsecured creditor, which in this case would be Matson.
In this case, I find it both proper and necessary to pierce the corporate veil, as Svatos has failed to properly represent her company. I will treat the defendant as one entity for the purpose of this judgment and make Svatos personally liable. The plaintiff shall have judgment against the defendant in the sum of $24,009.26 and costs.
Svatos was acting as an undisclosed agent. A risk of undisclosed agency is personal liability. Svatos did not follow the proper precautions to make all parties aware of the corporation's presence. Hence, the judge's ruling to view Svatos and his company as one entity. This ruling does not make all shareholders and directors liable in other corporations, but it is a cautionary tale to those who act incorrectly when attempting to operate as businesses. In your ventures in the business world, take care to act honestly and to strictly adhere to the Business Corporations Act or any other governing law.
Pause this video to discuss the following questions in your classroom environment. Here are the answers. Svatos could have avoided this outcome by naming her corporation Edmonton Hobby. She also could have kept better records indicating her use of the official corporate name, so that she'd be able to provide the lease for the business premises. Lastly, she should have adhered to the contract's conditions with H&D Hobby and simply declared bankruptcy. Now, when you start your business, it'll be beneficial to know how to smartly name your corporation. Don't allow for any communication errors between trade names and official corporation names. Incessantly collect records to prove your every move as a business. Properly handle your contracts and act with the utmost good faith.